Victim stated she was in fear for her life when he placed the knife to her neck and made those statements. So you made statements with her accusing her of sleeping with someone and said you were going to kill her. And you had a knife to her throat. The court is calling 2022 CR 6780, State of Texas versus Bradley Castilla. Could I have parties approach for the state?
Catherine Pollard for the state.
For the defense?
Jim Aldersdorf.
Are you Mr. Castilla?
Yes, ma'am.
All right, Mr. Castillo, next time you should know sharks are not allowed in court, okay?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Castillo, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Castillo, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea bargain agreement? Satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea bargain agreement, there's a $500 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense?
Yes, ma'am.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your
Counsel, are there any such motions?
Honor. No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, no harmful or injurious contact with Priscilla Acosta and the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Honor.
State any evidence.
Yes, Judge. The state would offer what's in Mark the state's objection.
No objection.
Mr. Castillo, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can proceed. Thank you, Your Honor.
Anything you wish to say on behalf of your client?
Judge, he's involved in a close relationship. The young lady is here. This is, even though this is my second time with him, I've formed a very good, strong opinion of Mr. Vasella. He's been very respectful. I think he'll be a great probationer. And again, he's got a very strong family with regard to his mother who's been here and his wife. They have 3 children together. So we'd very much like to be on the 22nd.
All right. So who is the person with you today? All right, so that's the complainant in this case, right? All right, I'm not going to allow for contact now. So he needs to get his life together. And part of getting your life together is finding out who you are, not having relapses. You understand? Because the pulling of a knife on the person that you say you love, and from what I read in the police report, it says, victim stated she was in fear for her life when he placed the knife to her neck and made those statements. So you made statements with her, accusing her of sleeping with someone, and said you were going to kill her. And you had a knife to her throat.
I was going to talk to you today because
Oh, you want a jury trial? Because here's the thing. People always say they want a jury trial because they think somebody's not going to show up. They think the complainant, we're back together. It's all lovey-dovey. But here's the problem. There's an issue in your household. And let me tell you what the issue is. The issue in your household is you use drugs. You have children in your household. You put a knife to the throat of the person you claim you love. And if you don't love her, at least it would be hoped that you would love your children. And when you did that, guess what? Your children know about it because the police are called to your residence. You've brought trauma and drama into their life, and they didn't ask for either one of you to be their parents. So I'm going to help them have a better atmosphere in their home. And part of having a better atmosphere in their home is having their father get his life together. You can still send money to the home for support, but you're not having face-to-face contact with her. And I know you all came to court together. I know she wants to show support for you. I know you guys want to hug up together, but this is what's called a honeymoon phase. But you still haven't gotten your life together. The only thing that's happened is this has happened. Now you're bringing her down here so she can say it didn't happen. And I guess she's going to tell me that the police just showed up. Nobody has an idea. Why did the police show up? Why did she say that you had a knife to her throat, threatening to kill her? And I'm not going to hear that today. You understand? So you have mom, dad? You have a mother and father?
I have to remember the second one.
All right. So your mother and father, I'm sure they'll allow you to stay with them until you get your life together. And if you're drug tested today, what are the results going to be? And no, before you answer, you are getting drug tested today.
Yes, ma'am.
So what the results going to be?
I should get them.
When's the last time you used?
I smoked weed a few weeks ago.
All right. See? And so from this incident, you still haven't learned anything. Because how old are your children?
13 and
Do you want them smoking weed?
Yeah.
By you smoking weed, that's telling them that it's okay to smoke weed. You understand?
Yes.
And are your children boys or girls?
Boys and girls.
All right. So let me just tell you what's happened at your incident at your house. You know how children learn to speak?
Huh?
Do you know how children learn to talk, how to speak, how to form words? They learn that from listening to everybody in their household. So if you have a little child that's using profanity, they're using profanity because people in the household use profanity around them. So what your daughter has learned from this incident is that if someone loves me, then it's okay for them to abuse me because they love me. That's how they show me love. And you know what your sons have learned from this incident at the household? They've learned that might makes right. And this is how I should show love to a woman that I'm involved with or whomever I'm involved with. The way I show love is I'm abusive. You understand? And what your daughters and your son are learning from your mom, their mom, for her to come down here and say that this didn't happen is we cover for the men that we love. I'm not having that in this court. You understand?
Yes.
Are you employed?
Yes.
What do you do?
I work in McDonald's right now.
Okay. I always tell people when you have children, wherever you work and whatever you enjoy doing, try to do that. All right. It's going to be 4 years deferred adjudication, $500 fine, probated. affirmative finding of deadly weapon, affirmative finding of family violence. There's going to be parenting classes with compadre y compadre. There's going to be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The remaining of those hours will be waived once you complete parenting classes. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be regular reporting. I'm going to want the UA hotline until further notice. I'm going to want field visits 2 times per month. There's to be the BIPP course, no contact with Priscilla Acosta until further notice. Probation, is there anything else he needs? And follow the recommendations of TAP. If TAP says that he is to be in inpatient treatment, we'll start with intensive outpatient treatment. Is there anything else you need from the court in order to be successful? Did you all drive down here together? Whose car is it? All right, so Ms. Acosta, you're going to be driving back home by yourself. In the courtroom, if he needs some money for bus fare, you can give him money for bus fare. But outside this courtroom today, you're not to have any contact with him. If the rules end up getting violated, he could end up going to prison for 20 years. Do you understand? I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You need to do better for your children. If you love them, how you show them that you love them is by making their house a safe haven. There's enough drama and trauma in the world to not have to come home knowing if dad's going to get in an argument or try to beat up mom or come home high. You understand? And where you are now today, this is just a starting point. You still have a chance to improve and be a good father and be a good husband if you're wanted back in the home. You understand?
That's right.
All right. Good luck to you. And do not let me find that you're having contact with her outside of this courtroom today, because if that happens, I'm going to sign a motion if it's presented to me, and you're going to be brought over to court wearing an orange outfit. Do you understand?
Yes, Your Honor.
All right. Good luck to you. Court is calling 2022 CR 0499, State of Texas versus Kayla White. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Surgery bar from this point.
And are you Miss White? All right, the defendant entered a plea on July 12th, and she applied for deferred adjudication. According to the plea bargain agreement, punishments be assessed at 5 years in the prison. There's a $1,500 fine. The state is remaining silent on the application, and they're taking in consideration 2022 CR 0814D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections? State?
From the state.
Defense?
No, no defense.
All right, the state is silent on the application. Is there anything you wish to say on behalf of your client?
Yes, ma'am. Thanks. From the very beginning of our representation, Ms. White has been probably one of the most diligent clients as far as keeping up with her case, with her settings, coming to see me, talking about it. And I would say from the very beginning, just our I guess plan for this case was about taking responsibility and doing everything she could to report that she would be a good candidate. She has gathered, and sometimes it's hard to wrangle a bunch of people to do letters of support, but she has gathered 6 letters of support that we have. I had not filed them with the court judge. I have them here, and I wanted to let you know this spoke about her. But if the court would like to see them, the state has had an opportunity to look them over. Comment. That way, when you work out something.
All right, any objection to the state viewing the letters? I'm sorry, to the court reviewing the letters?
No objection, Your Honor.
And if you would, Judge, I can.
Yes.
Thank you.
Thank you. All right, you may continue.
And what the court will see in the letters is pretty much what I have found and discovered about Ms. White through our interactions in the state of this case. She is a goal-oriented person. She's a person who works quite a bit, oftentimes She's working these 12-hour shifts. Over at IHOP. She's been there for quite some time now, and just recently, within the past couple of months, she named with value management there at the IHOP location. She has a couple letters there from individuals that she works with, Siobhan and Fredo. Fredo Ruiz is the regional supervisor. Sorry, Alfonso Ruiz is the regional supervisor this area, and he sees her to be a diligent person, the kind of person who takes responsibility beyond what's expected of her. Her coworker, who also does part-time managing, I think is very dependable, the kind of person you can count on in pretty much any type of situation. Anytime I've had phone calls or any correspondence with the data, she has come in, taken this time out of her work schedule, her life schedule, to be there to discuss the case and continue to pass it. Going over the PSI, Judge, there are, as we see, there's some history that she has with mental health in which she's addressing. She's seeking treatment now and is undergoing those, taking medication in order to address whatever issues that she may have. She's made significant improvements over the years to address those issues. But she stays on top of it as much as she possibly can. It can be expensive to do those things, but she does everything that she can. Regarding her employment, it is probably the centerpiece of this right now. I know it's difficult for her and weekends meet, but she keeps plugging away at this, doing everything that she can. In reference to the companion to trauma, in the PSI interview that was done with her, she did indicate that she felt that Ms. White is a good candidate for probation, is the kind of person that she believes would do well with the structure and all the requirements that are asked of her by the court probation. In conversations that she and I have had, she's had an opportunity. She herself has expressed to me, without prompting anything, about how this court speaks to and addresses issues as they come before the court. I think that she admires those things because it's something that can help to keep her on a path that she believes she's on with everything else. She's working really hard. She has a good family support system. She actually had a very loving relationship with her husband. However, they cannot have any contact during the period of time. So she has abided by that, but she does pretty much everything that she can for that support system, for that relationship, the things that she needs to do in order to sustain that.
All right. So what I'm interested in, even though the state is taken in consideration and I look at everything as a whole, is that she had an injury to a child on June 22nd. And it is assault on July 15th. Now understand that assault is involving her niece, and her niece, I guess she did an affidavit of non-prosecution. She doesn't want to be a part of it. She thinks that she shouldn't be even on probation for this. So I understand that. So we're going to put that to the side for a minute. I want to know what is happening with this injury to a child case. What is that about?
So to be very general about it, Judge, there were quite a few people during the pandemic that were living in an apartment, a single apartment. The primary case, without getting too deeply into any conjecture or anything like that.
Yeah, and honestly, with regards to the injury to the child, if people want to say allegedly, I'm fine with everything you're about to say. I'll put allegedly in my mind in front of it, but I want to know what's going on with that so I can make a decision on whether or not I should grant her application.
Yes, ma'am. So my understanding is that the child was actually the son of an individual living in that apartment, named Brandon White. I believe he has taken a plea on this case and is currently serving for this. Ms. White was residing in that apartment with her husband at the time. They had kind of a separate area. The way that the apartment was set up, they were living in a separate area. During this period of time, I don't know that this is, I believe there will be several witnesses that can attest to this, that she worked these long shifts during that period of time. They pretty much spent all of her time, or the significant amount of her time there at these shifts. They didn't have a whole lot of interaction with the victim, procedural in this particular case. However, her name was mentioned to the interview none of the victim. And so that's, I believe, just having the fact that these people were all in this apartment that resulted in these charges.
All right. Do you have any objection to the state telling you what's in their file?
No objection, Judge, obviously just for factual purposes.
All right, I'm putting it allegedly in front of everything in my mind. State, can you tell me about the injury to the child?
Yeah, Judge, just to give me a minute to refresh my memory. I'm sifting for Michael, but,
Okay.
and it's being taken into consideration. The defendant was indicted on that one, count one for striking the victim with a paddle, striking with a belt, striking with a hand, and then count two by omission, causing bodily injury, because she assumed fear, custody, and control of Alexander White.
And I don't know if both of you all want to step back and address what's in the police report and then come back up.
Okay.
Yes, so if defense and state, if you can look over that, so it can help me make a decision on her application.
Okay.
All right.
Just to confer about what's in it, to address the court.
Yes.
Okay.
Yeah. And this is from the 226. Did they ask that to be brought here?
The
The grand jury? Did they ask that to be brought
Oh,
here?
no. You know what? I'll take it back.
All right, do you have some white out?
I didn't see it.
Oh, congratulations, Rashawn. That's beautiful. You're stunned. So that's okay. Oh, let's see the beautiful flower arrangement, Rashawn. Oh, see the attorneys. Yeah, let's see that. Oh, that is so gorgeous.
Really nice.
It is. So attorneys over there, don't knock that over. Because I don't know what she will say if you knock those flowers over. Here.
Judge,
Oh.
reviewing the report.
Okay, so we are back on the record. Ms. White, if you can come forward. And again, I'm taking this as allegedly. All right.
And
Yes.
Judge, the child in this case was taken to the hospital, and there were several co-defendants. But he did make allegations that the defendant in this case spanked him, hit him with a paddle, hit him on his chin. She admitted to spanking him. She said she got the paddle as a deterrent, but had never used it on him. She also admitted to spanking him with a belt 3 or 4 times. So there are admissions that she did cause an injury, and the child himself did say that she caused an injury as well.
All right. And again, I'm putting allegedly before my mind in my mind. But is there, do you want to call your client as a witness to address these issues?
I can address them, Judge, unless the court
It may be best for her because Ms. White, what I'm looking at, and I know the state is taking it in consideration, but I have technically before me 2 violent offenses. One is the injury to the child that was alleged to have been committed on June 22nd, 2021. And then a month later, we have this assault choking from July 15th, 2022. And so I'm trying to figure out whether or not I should grant your application. And I need more information that's not in the PSI report. So if you raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense, do you have questions?
Yes, so Kayla, if you could just explain, the prosecutor just an opportunity to kind of the And I know that you did want to get some exclusion. So we can address the court regarding, especially with this.
So during the time that Raymond was dating my niece here on this, he called both of us aunt too, but he did not discern between which aunt two. Raymond never discerned that it was his girlfriend to his child. And I had to explain to him, I said, do you understand that you were basically dating your step niece and you have to explain like this all to your child? We went through that bundle. We explained to Brandon and Kayla that since they decided to date each other instead of taking care of what they needed to for their own children, we were going to step back and stop as far as we would help them with a place to stay until our lease ended. And after that, we were rendering no more help to them. The last time I had spanked Alexander had been in December of the year prior. And after that, I had spoken to Brandon and he said that he had checked because when I did spank him, Alexander had moved and jerked. And so when he did that, I stopped. I told Brandon, I said, look, since he's moving, he's jerking, I will not spank him any longer. I won't recommend him. You need to be the one to do this. You're his dad. You need to be the one that steps up. And
Real quick, and just talk about what was said. You explain, did you ever strike?
this, I never struck him with the paddle. I spanked him once with my hand, once with the belt, and I never spanked him again because he jerked both times. And my last thing was I didn't want to injure him.
And so, as you heard, Judge Boyd is talking about the fact that there's two different cases in a certain period of time. And so, I know that you've had an opportunity during the assignment of the judges of the give that. But regarding that specific instance, it was involving the kid. Okay. And so, if you could just explain to the judge briefly what transpired.
I had asked Caitlin to wash the dishes that have been sitting there for several
Okay,
days.
and just so both parties know, I've read the PSI report.
Very good, Judge.
Yes.
Okay, just want to make sure.
No. I always read the PSI report with a fine tooth comb, and I've read all the police reports.
And I didn't want to be too redundant, Your Honor. I apologize.
Oh, no problem. I know, just so everybody knows, everything that's put in front of me, I always read it. Like every single line, every comma, every semicolon, I always read it.
Great.
So, I still have concerns with the injury to a child case, even though it's being taken in consideration in this case. And the state is silent, but I think we need to reset this and state if you can explain to me or have someone explain to me why that case is being taken in consideration. I don't know. Maybe it wasn't provable. I don't know. Maybe there's some other reason or some information that they have that I don't have access to, because I don't know anything about that case other than what the charge is. And I'm just a little bit concerned that we have two violent offenses so close together. So, State, will Mr. Villarreal be here tomorrow?
Yeah, Judge, he should be here tomorrow.
Okay. All right.
And Your Honor, if there was a specific time that the court one is here, I know that, and this is just me asking on her.
Oh, no.
I know that she does work tomorrow, and I know that this is more important.
When is your next off day?
The next off day would be Wednesday.
All right. Norma, are we able to fit this in here Wednesday of next week? What other off day do you have other than Wednesday?
I work overnights, so it varies with my employer.
But I mean, state, you all will be here on Wednesday,
I
correct?
mean,
In the building?
we'll be here every day.
Yes. So let's just do a Wednesday at 9. Everyone needs to be here exactly at 9 a.m.
Very good.
Okay. All right. So we'll bring you. I don't want you to lose your employment. So we'll be back on Wednesday at 9. And State, if you can let Mr. Villarreal know what my concerns are.
Yeah, we'll do that.
Appreciate this. Thank
All
you.
right. Thank you. You're welcome. Court is calling 2022 CR 8231, State of Texas versus Dimitri Gomez. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Scott McCrum from Mr. Gomez.
And are you Mr. Gomez? Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case? And did you review that with your client?
Yes, I have and I did.
Court will find that the state is in compliance with discovery. Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Okay, I'm going to need you to speak up a little bit for me. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, next, Mr. Gomez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with assault family second offense? That's a third-degree felony. The range of punishment is,
To the table with a repeater
No, no, no.
enhancement.
are you all proceeding on the repeater enhancement allegation?
Here, Your Honor.
Okay. I was looking at that and I was like, oh, so do y'all want to circle the repeater and initial it, please? And if you could let your client see that. All right.
His signature too, or just?
No, just yours. All right. So, Mr. Gomez, the state is proceeding on an assault family second offense. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If the state is able to prove the repeat offender enhancement allegation paragraph to the court, then your range of punishment will be as a second-degree felony. And the range of punishment will be 2 to 20 years and still up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? I'm sorry?
Did you understand he has all those rights?
Okay. All right. Are you understanding what's going on?
A little bit of it,
All right. So we're going to start over a little bit because I want to make sure you understand. Do you understand that you have a plea bargain agreement with the state? All right. Do you understand that I don't have to follow any plea bargain agreement you worked out with the state? Do you understand that? All right. Do you understand that if I don't follow your plea bargain agreement, you can take your plea back? Do you understand that? And the fact that you entered a plea will not be used against you. Do you understand that? All right. Do you understand you have a right to jury trial? Do you understand you have a right to have your attorney or yourself cross-examine or confront or question any witnesses that the state would call? Do you understand by entering this plea bargain agreement, you're giving up those rights? Did you understand you have a right to remain silent, which means that the state doesn't have to call, it's not allowed to call you as a witness to testify? Do you understand that? Do you understand by entering this agreement, you're giving up that right? Did you intend to enter into a plea bargain agreement in this case and give up those rights? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
You believe he's currently competent?
Yes,
Do you believe he was legally sane at the time of the offense?
yes.
Mr. Gomez, has anyone threatened you to enter this plea? Has anyone coerced you to enter into this plea? Has anyone promised you anything other than this plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it? According to the plea bargain agreement, and you want to initial that for me, counsel?
What are we doing, the count?
Thank you. And could you let your client know? Did you understand, according to the plea bargain agreement, you are agreeing that you've previously been convicted of a different offense? Did you understand that? And the state is asking that your punishment be assessed at 4 years in the prison. Do you understand that? There are no applications, which means you didn't apply for probation. Do you understand that? Do you understand that you did not apply for deferred adjudication? Did you understand that the state is going to take in consideration after this plea or dismissed after this plea, cause number 2022 CR 5520. Did you understand? Did you understand that they're asking for an affirmative finding of family violence? Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand? Did you understand with an affirmative finding of family violence that you are not allowed to be designated as primary custodial parent? Did you understand that? Did you understand there's to be no contact with April Guerrero? Did you understand if you do not show up for your sentencing, you'll be subject to the full range of punishment? So what that means is I'm going to give you a date to come back for sentencing. If you don't show up for that date, I could sentence you to up to 20 years in prison. Do you understand? So you've agreed to 4 years in prison, but if you don't show up, I can sentence you to 20. Do you understand? Defense, is that the plea bargain agreement?
Yes.
State, is that the plea bargain agreement?
Yes, Your Honor.
I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it? Did you understand by signing that you're waiving your right to appeal? Did you understand the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand? Counsel, have there been any such motions?
Yeah.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest? All right, state any evidence?
State offer State's Exhibit 1 and attachments to evidence.
No, Judge.
Mr. Gomez, I'm showing you this document. It's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand that? Did you sign it in all the places you were supposed to sign it? Again, did you understand you have a right to jury trial? Did you understand you have a right to remain silent? Did you understand that you or your attorney have a right to question or cross-examine or confront any witnesses the state would call? Did you understand that today, in order to prove their case, the state is not going to call any witnesses? Did you understand that? Did you understand they're going to seek to prove their case with police reports and witnesses' statements? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. All right, Mr. Gomez, I'm going to read to you the repeat enhancement paragraph. I need to know if that's true or not true. Do you understand? It says, and it is further presented in and to said court that before the commission of the offense alleged above, on the 4th day of June, AD 2018, in cause number 2017 CR 4140W in Bexar County, Texas, the defendant was convicted of the felony of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Is that true or not true? Court will review State's Exhibits 1 and attachments. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true in State's Exhibits 1 and attachments. All right, how much time are you asking for?
30 days, Judge.
All right, Ms. Ferguson, can I have a 30-day reset for sentencing on Mr. Gomez? And I'm sorry, State, do you have any objection? All right, it's going to be October 20th at 9 a.m. And you're going to get a reset form, so you'll know you need to be here. You understand? All right, and
Thank you, Judge.
all right, and who's coming with him?
That's his mother.
Okay, all right,
And the warrants are recalled.
yes.
Thank you.
And make sure the warrants are recalled in each case.